A woman in Connecticut went home after a bad shift, wrote something insulting about her boss on Facebook, and got fired for it. Then the federal government took her side and filed a complaint against her employer, not on free speech grounds. The First Amendment never applied to her at all. If you have ever typed something about work and then hovered over the post button, this is the video for that hesitation. Because there is a rule that decides whether you can be fired for it, and it is almost never the rule people think. Ask most Americans what protects what they say online, and you get the same two words: free speech, First Amendment. Now here is the part that surprises people. For roughly 6 out of 7 American workers, the First Amendment has nothing to do with their job. Not a little. Nothing. The First Amendment does not say everyone must let you speak. Read who it is aimed at. Congress shall make no law. It restrains the government. Lawyers call that state action. The Constitution binds the state. Your employer is not the state, unless your employer literally is the state. So, if you work for a restaurant, a hospital chain, a tech company, a warehouse, your boss firing you over a post is not a constitutional problem because there is no government in the story. The Constitution never enters the room. And on top of that sits the default rule of American employment, which is at will. Absent a contract or a specific statute, either side can end it any time for a good reason, a bad reason, or no reason at all. Put those together, and the honest answer to, can they fire me for a post, is usually yes. But usually is not always, and the exception is a law almost nobody associates with speech. In 1935, Congress passed the National Labor Relations Act. People file it mentally under unions, and then stop reading. Section 7 is the part that matters here. It protects employees who engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. Read that phrase again. Other concerted activities, not union activities. Other. Congress wrote a category wider than unions, and courts have been filling it in ever since. Concerted means you are not alone in it. Talking with coworkers, acting together, or speaking on behalf of the group about something that affects the group. Mutual aid or protection means it has to be about the work, your pay, your hours, your safety, your conditions. And you do not need a union. That is the part people miss. The Supreme Court settled that in 1962. January of 1959, a machine shop in Baltimore. The furnace had broken. The shop was bitterly cold. A foreman told the men that if they had any guts, they would go home. One of them said he was going home. It was too cold to work, and 7 workers walked out together. No union, no vote. They never even made a demand. They just left. The company fired them, and the court said they were protected anyway. Employees do not lose the right to act together, the court held, merely because they never presented a specific demand to their employer. Which brings us back to Connecticut. Dawnmarie Souza was an emergency medical technician. After a dispute at work, she went home and posted a vulgar, insulting comment about her supervisor. Coworkers replied in the thread, and the conversation turned to how the place was managed. She was fired. The company said it was about her work performance. The labor board's theory was that the real reason was the Facebook thread, and that separately, the company's online conduct policy was written broadly enough to ban that conversation outright. The labor board's regional office issued a complaint. The theory was not that her post was free speech. It was that a group of coworkers talking about their working conditions is concerted activity, and that a policy broad enough to ban that is itself unlawful. In 2011, the case settled, and the company rewrote the policy. Then it got stranger. In a Connecticut sports bar, an employee clicked like on a former coworker's Facebook post, complaining that the owners had botched the payroll tax paperwork. Another employee added a short comment. Both were fired. The labor board held that both the comment and the like were protected. A federal appeals court agreed. Clicking a button, in that context, counted as taking part in a conversation among coworkers about a shared problem with their pay. Now the part that keeps this from being terrible advice. This protection is narrow, and it is easy to fall out of. It has to be tied to other employees and to the work. A lone complaint about your own schedule, with no connection to anyone else's conditions, generally is not concerted activity. Venting because you are annoyed is not the same as raising something the group shares. And there is a second limit from 1953. Technicians in a labor dispute handed out leaflets attacking the quality of their employer's broadcasts without ever mentioning the labor dispute. The court found that crossed into disloyalty and lost its protection. Attacking your employer's product, untethered from a workplace grievance, is not the same as talking about your pay. And then there is the list of people the statute simply does not cover. If you are a supervisor, an independent contractor, an agricultural worker, a domestic worker, or you work for a railroad or an airline, Section 7 is not yours. And neither is it if you work for the government. The statute defines employer in a way that leaves government out. So the one group of workers who do have constitutional protection has no federal labor law protection here at all, and the enormous group with no constitutional protection is the one this statute was written for. The protection you get depends almost entirely on who signs your paycheck, and the two systems barely touch. So, take the other branch: a teacher, a firefighter, a city clerk, a state trooper. Your employer is the government, so the First Amendment is finally in the room. That does not mean you can say anything. The rule starts in 1968 with a teacher in Illinois named Marvin Pickering, who wrote a letter to his local paper criticizing how the school board was handling money. A tax increase, a bond issue, how much went to athletics. The board fired him, saying the letter was detrimental to the efficient operation of the schools. The Supreme Court sided with him and set up a balance that still governs. The employee's interest in speaking as a citizen on a matter of public concern weighed against the government's interest as an employer in the efficiency of the public services it provides. Two things have to be true before you even get to that balance. You have to be speaking as a citizen, and it has to be on a matter of public concern. In 1983, the court made the second one bite. An assistant district attorney circulated a questionnaire around the office, and the court found most of it was an internal office grievance, not a public issue. That firing stood. It was close, 5-4. But the first requirement is where it really turns, and the two cases that show it are almost the same story with opposite endings. Richard Ceballos was a supervising deputy district attorney in Los Angeles County. He looked at a search warrant affidavit, concluded it contained serious misrepresentations, and wrote a memo saying the case should be dismissed. He says he was reassigned, transferred, and denied a promotion for it. He lost, 5-4, because writing that memo was his job. When a public employee speaks pursuant to their official duties, the court held, they are not speaking as a citizen at all, so the balance never even begins, and the Constitution does not protect it. Now Edward Lane. He ran a youth program at an Alabama community college. An audit he conducted found a state representative on the payroll who was not coming to work. He fired her. The federal government prosecuted her, and Lane testified at her trial, under subpoena, under oath. Soon after, the college president laid off 29 employees citing budget cuts, then rescinded almost all of them. Lane's stayed. He won, unanimously, because testifying in a courtroom was not part of his ordinary job duties, even though everything he testified about came from his job. The question, the court said, is not whether your job gave you the information. It is whether producing that speech was itself your job. Two public employees, both reporting wrongdoing they found through their work, opposite results, and the line between them is that thin. And there is a sting in Lane's case worth knowing. He won the constitutional question and still collected no damages from the man who fired him because the rule had not been clearly established at the time. His separate claim to get his job back was sent back down to the lower courts. Which brings us to the question that started this. Can you be fired for going to a protest? Run it through the same two questions. If you work for the government, it is the Pickering balance. Are you speaking as a citizen on a matter of public concern? And can your employer show real disruption? If you work for a private employer, the Constitution is not in the room, and Section 7 only reaches you if what you were doing connects to your own workplace conditions. A walkout over your pay can qualify. A rally about a national political issue generally does not. That leaves state law, and it is a patchwork. According to the trackers that follow this, only a handful of states have statutes broad enough to protect off-duty political activity outright. A larger group have narrower protections for lawful off-duty conduct, often aimed at things like smoking or lawful products rather than politics. and in much of the country, there is no such statute at all. So, the honest answer is that where you live changes the answer, and most people have no idea which category they are in. Here is the whole thing in one line. Whether you can be fired for what you post depends less on what you said than on who employs you. If that is the government, the Constitution is in the room, filtered through a balancing test that turns on whether producing the speech was your job. If it is anyone else, the Constitution is not in the room at all, and your protection comes from a 1935 labor statute that only reaches you when you were acting with your coworkers about your working conditions, which means the safest thing to know is the narrow thing. Talking with the people you work with about your pay, your hours, and your safety is the speech the law is most likely to protect. Almost everything else at work is at will, and at will means what it says. Now you know.